Yep. Today, June 18th, Ada County Courthouse, Judge Hippler, Bryan Kohberger, defense, and the prosecution all came together and had a hearing. It was a double motion, so it was split. Courtroom was open in the early session, it was closed in the latter. You have to forgive me. I saw my eye surgeon today, so I get to wear my cool sunglasses to protect my eyes even indoors. But Bryan Kohberger, he might not be too happy with Judge Hippler's decision and his ruling when it's released. And I know my voice, when heard by many, it may not spell out the very things that you want to hear. But hey, it's just my opinion and it's my thoughts. And I'm ARHayes. This is Convict's Thoughts. Thank you for being here. That's right, ladies and gentlemen. I watched the very same hearing that just about all of you did. And I might just have a totally different takeaway from it all. And some of you that truly feel Bryan Kohberger is innocent and should be let out of jail, and this entire case should be thrown out or the death penalty removed, like I hear many other people saying is gonna be. You might not like what I have to say because I have a different interpretation of what I saw today than many others. I don't feel it went well. I don't feel Ann Taylor stepped to the podium thinking that she could do so with such confidence that her motions were being heard by Judge Hippler. Again, he had that pose. Judge Hippler just didn't want to be there. Remember all the way back to the very beginning when he told everybody flat out he did not want to be ruling over this case. And guess what? Today is just another showing of that very same thing. He really doesn't want to have to maneuver through all of the motions and all of the filings in this case with all the drama and the speculation and the rumors and the narratives. Oh man, it's got many of us just shaking our head, just wondering, can we get to trial already? Can we get to trial already? And I think Judge Hippler, during this very early morning open session, pretty much clarified for both sides to be prepared to be at trial August 11th. Now, Ann Taylor did ask for a continuance, and that's what we were able to see today, and she specified many different reasons. We didn't hear the reasoning based upon like the alternative perps or the things that probably were most likely discussed in the later session that was closed to the public, but we did hear the very filing that she did for the basics when it comes to a continuance. She still has not gotten through all of the evidence, ladies and gentlemen. She straight quoted the 60-something terabytes worth of evidence that was turned over to her. She has not worked her way completely through. She obviously is still discussing the problems with the mitigation portion of this case. And ladies and gentlemen, it's not just capital cases that go through mitigation. I want people to understand that. All cases have a mitigation aspect if there's going to be a sentencing tied to that, even plea bargains. They have to go step by step through the basics of a mitigation to see if there's any mitigating circumstances that can lessen the harshness of your sentence. They also look at the aggravating factors. So it gets weighed out in every single case. I've had it done in all of mine. They look at the family history, what transpired in your growing up years, what has happened in your life, good and bad, that could lead to the very crime that you committed. Mitigating circumstances can help you. I have had it to where I was facing 5 to 7 years in the penitentiary, and because of my mitigating circumstances outweighing my aggravating circumstances, I was able to get less time, down to 3 years rather than 5 to 7. So yes, it's an important aspect, especially in a death penalty capital case, because it could legitimately take the death penalty out of the hands of the jury, because they could weigh out the mitigating circumstances that could potentially have led to the crime being committed and lessening the aggravating factors within that crime. I know many that would look at this case and value those mitigating circumstances to try to help every sense of Bryan Kohberger's case, including his mental status, his emotional chaos, whatever might have been happening in his life. They want to look at that. They want to talk to the family members and the friends and the people that associated with him so that they can get a better sense of what Bryan Kohberger was as a person. They also want to reach out to any type of doctors, counselors, mental evaluators that could lessen the burden on the jury by giving the very reasoning why Bryan Kohberger acts and thinks the way that he does. Ann Taylor asked for a continuance on many of reasons because she directly specifies that she is worried that Bryan Kohberger is not getting the quality of counsel that he could potentially need and deserve in this case. And that's all based upon the case load, the evidence, and all of the things happening within this case, including the defense's own investigation into an alternative perp. It all takes time. It takes effort. It takes manpower. And it seems as though Ann Taylor, even at the court hearing my wife and I attended, very clearly stated they didn't have that manpower. They didn't have the capability to dig through every piece of evidence that the actual prosecution provided. And that was setting them back in a timetable of being able to provide Bryan Kohberger the best defense possible when this goes to trial. You see, I don't think Judge Hippler is going to grant that continuance. Like I said, I don't know what happened in the afternoon session, but let me bring a point to you that goes through my mind, and I just want to keep your mind open, whether you feel as though he's completely innocent, whether you're on the fence where you believe in innocent until proven guilty, or maybe you've just damn well convicted Bryan Kohberger already of this case. You still have to understand the time frame of how this hearing happened today, with the open portion of the hearing first about the continuance and the closed portion after the fact about the alternative perp defense. Now see, my thought process, my thinking leads me to think I would have felt as though it would have been more important and more logical for the defense to try to get that alternative perp defense argument in prior to the continuance, because I would want the judge to weigh out the fact that there needs to be more investigation. There needs to be more evidence looked into. There needs to be a deeper dive into the potential of either somebody else completely committing this crime, or potentially even more than that, a wider range of people that could have potentially committed this crime. And remember, we've gone through the step-by-step process that Judge Hippler made very well known that Ann Taylor was going to have to jump through the hoops for the alternative perp, providing the evidence before he would allow that type of testimony at trial. Now, I've been very vocal that I felt as though a name-based alternative perp defense is not going to happen at this trial. They're not going to point fingers. They're not going to say names. They're going to utilize an alternative perp defense based upon evidence within the crime scene that could lead people to believe others could have committed this crime outside of Bryan Kohberger. I don't believe that the defense has any chance of being able to point the finger at certain individual or individuals, naming them as suspects under investigation in this case. If that was the case, I would have believed that Ann Taylor would have bypassed Judge Hippler, maybe given him the respect factor of notifying, but she would have been at the Idaho Supreme Court door knocking to present such evidence and to either get the case stalled against Bryan Kohberger to launch a full-out investigation into the found evidence. But on top of that, she could have asked for a dismissal. None of that has transpired as of yet, but we don't know what the outcome of today's hearing and what was argued is. But from my perspective, and look, I'm not the smartest guy in the world. I don't have the most knowledge, but I do have a little bit of experience. And I'll tell you, when these motions are filed and these arguments are made within a courtroom, especially based upon a continuance of the trial dates, you want to get everything compacted in before that judge can make that decision. Now, he did say he was going to take everything under advisement. He was going to take everything under consideration, and he would make his ruling here in the advanced future, which could possibly mean that he is going to take in the argument of the alternative perp and weigh all that out. I'm not saying that's not going to happen. I'm just telling you, my opinion is it's not. I think Judge Hippler is ready to rock and roll and take this to trial. And I know that even with the launched investigation into the dateline and the leaked evidence, it hasn't halted what's happening to Bryan Kohberger and his image and the so-called narrative being painted against him, because guess what? Prime is coming out with the docu-series, which got mentioned today in the actual hearing. Within that, you have testifying witnesses that should be under the gag order. And they are talking in a documentary series put out for all to watch right before this trial. And remember, two of these people speaking are the ones that walked into the crime scene and supposedly found Xana's body before the 911 call. They were the first within the crime scene outside of Dylan and Bethany. How in the hell are they able to even have been a part of this docuseries, being able to speak and share their thoughts and their opinions? And yet the judge just looks at it as if it's all good and okay. They should be excluded as witnesses. Their testimony should not be valid or utilized in this trial. But outside of that, because that doesn't hurt the prosecution's case, because those two aren't going to be testifying to legitimate evidence against Bryan Kohberger. They're not eyewitnesses of him within the crime scene. They're not eyewitnesses to the crime happening or the car or anything of that nature. These two are just legitimate witnesses to back Dylan and Bethany. And remember, the 911 call has been deemed admissible at trial, and two of these individuals were a part of that. They're going to have to testify at trial, especially Hunter. And they're speaking in a documentary followed by a book that's being released again after the docuseries right before trial. And look, I used to read James Patterson and loved every single one of the novels the man wrote. I think he is an intelligent, amazing dictator of captivating your thoughts and everything within his writing. This is a low blow. I am shocked that James Patterson could not have held this off till after the trial or further down the road after a conviction and everything of that nature. But what that tells me is James Patterson and the Amazon segments feel that there's a potential chance that Bryan Kohberger gets found not guilty at trial. And they're cramming this in before it becomes obsolete and worthless. If Bryan Kohberger was found not guilty at trial, this docuseries, this book means nothing. It's all out the window. Howard Blum, Bloom, Blue, blah, blah, whatever, his whole credibility gets shot as all of this as well. But here we are. The day has come. The day has gone. This shall be the last court date before we actually go to trial. They're going to begin the process of working through seating a jury. And Taylor and the defense team is going to continue to work to get those people that won't talk to them currently to talk to them so they can finish up their mitigating circumstances and get their mitigation process finalized for the sentencing portion of this case. Now you see, here's where the difference between a non-death penalty and a death penalty case is. The mitigation has to be complete before a capital death penalty case goes to trial and moves forward. In a normal case, many like what I've been in, that involves simple burglary or theft or a simple felony charge, the mitigation process can actually happen after said verdict, whether you're found guilty or not guilty, and that's when the judge will set a time for the mitigation package to be completed before sentencing. It's a little easier for a non-capital case to get that complete. Much easier, actually. Takes a couple of weeks. In most cases, when it's your first offense, or even if you do have prior offenses and you are looking at very basic either probation or short-term penitentiary time, they do a pre-trial mitigation package that will flow directly into your actual after-the-fact mitigation before sentencing. This is where they'll deem whether you're eligible for probation or not. They can either state that you're probation eligible, you're probation or prison eligible, or you're just straight prison time eligible. So that does matter across the board, and this is going to be very, very important that Ann Taylor gets this finished and finalized. And it sounds like she's struggling because people don't want to talk to her. And do you blame them? Who the hell wants to come forward and talk to anybody in regards to this case when, if you do, your name's getting thrown to the masses and you're going to get drug into the dirt and talked about all over the place? You're going to get doxxed, your home address is going to be given out, and everything about you is going to be thrown out there. So if you've smoked a J in your day, if you've had a cigarette or a beer or two, everybody's going to convict you of being a part of this crime. Sorry, I had to throw that in because that's just an irritation that I have lately. This is a dead serious situation. Bryan Kohberger is going to trial and his life is on the line, and there's nothing that's going to take that away. Judge Hippler is not removing the death penalty from this case based upon what Ann Taylor has filed and motioned for. I know people are going to disagree with me, including other content creators that have put out the whole bit of their theory and their thoughts, and they've gone over the paperwork, and that's where they stand. Death penalty's off the table. I doubt that. I don't see it. This is a capital case, and it's going to continue to be. 4 lives were taken in a brutal manner, And whoever goes to trial for this, whether it be Bryan Kohberger or a potential alternative perp suspect sometime down the road, this is a capital case and it's going to stay that way. There's no plea bargains. There's no offers of lowering down the sentencing guidelines for this case. This is where we're at. We're ready for trial. We're going to work through the next month to see if we can get a jury sat, because August 11th is not far away. I'm not going to be able to see it. As you can see in my styling situation here, I won't be able to see, but I'm okay with that. I'm okay with that because with all of you, we're going to keep our minds open and our eyes focused on what the system is doing. And I guarantee you, this case isn't going nowhere. It's gonna, if a guilty verdict is found, we're gonna be talking about it, and then we're gonna be working through the appeal process. If a not guilty verdict is found, we're gonna be talking about it as Bryan Kohberger would be set free. And then we'll wade through everything that we learned during the trial and discuss it all. Whether it's guilt or innocence on your mind, there's going to be conversation for days because, look, nobody can stop talking about it right now. It's not going to end tomorrow. I appreciate you stopping by and listening to a little old guy with an opinion. Whether you like it or not, I shared it, and I appreciate you for being here for A Convict's Thoughts with ARHayes. This is the Idaho 4 case discussion against Bryan Kohberger. Trial coming to a town near you very, very soon. Have a good night.